The International Court of Justice have ruled in favor of the Gambia in the genocide case that the country filed against Myanmar for its genocidal crimes against the Rohingya minority Muslim group. On November 11, Gambia submitted a 46-page application to the International Criminal Court of Justice in The Hague, alleging that the Republic of the Union of Myanmar has violated its obligations under the 1948 Conventions on the Prevention and Punishment of the Crime of Genocide for its genocidal actions against the Rohingya people. Details of that in this report.
The International Court of Justice on Thursday delivered verdict in response to Gambia's request for the indication of provisional measures on the application of the Convention on the Prevention and Punishment of the Crime of Genocide against the Rohingya Muslims. The West African state had asked the world's highest court for provisional measures to require Myanmar to immediately take all steps to prevent genocidal acts, including to stop and prevent further genocidal acts, to ensure that security forces do not commit or incite genocidal acts, and to preserve all evidence related to the military's crimes. The court ruled that the Gambia has the prima facie to submit its dispute with Myanmar before the court on the basis of alleged violations of obligations under the Genocide Convention. This weekend's Myanmar's admissibility challenge against the Gambia on the basis of Article 8 of the Genocide Convention. The application, according to the ruling, was instituted in Gambia's own name on its own rights under the convention. The fact that the Gambia sought and obtained the support of other states or international organizations in the case does not pre-exclude the existence between the parties of dispute relating to the Genocide Convention. In the court's view, the Rohingya in Myanmar appeared to constitute a protected group within the meaning of Article 2 of the Genocide Convention, and that the measures Myanmar took to protect the Rakhine state was not sufficient.
The court takes note of the statement of Myanmar during the oral proceedings that it is currently engaged in repatriation initiatives to facilitate the return of Rohingya refugees present in Bangladesh, and that it intends to promote ethnic reconciliation, peace and stability in Rakhine state, and to make its military accountable for violations of international humanitarian and human rights law. However, in view of the court, these steps do not appear sufficient in themselves.
By this ruling, Myanmar is obliged to present before the court a report in order to show all measures it will take towards the protection of the Rohingya Muslims within 4 months and after every 6 months thereafter.
The Republic of the Union of Myanmar shall take effective measures to prevent the destruction and ensure the preservation of evidence related to allegations of acts within the scope of Article 2 of the Convention on the Prevention and Punishment of the Crime of Genocide. 4. Unanimously, the Republic of the Union of Myanmar shall submit a report to the court on all measures taken to give effect to this order within 4 months, as from the date of this order, and thereafter every 6 months, until a final decision on the case is rendered by the court.
Public hearing on this case, which began on the 71st anniversary of the United Nations Genocide Convention, was concluded on the 12th of December 2019, giving the court a period of over 1 month for deliberation. Gambia's Attorney General and Minister of Justice Abubakar Batambedu said that the aim is to get Myanmar to account for its action against its own people, the Rohingya. For iAfrica News, I am Julden.